Welcome to The Heart of the Matter, a podcast that covers legal developments from around the world. I'm your host, Stephen Lai. This podcast is brought to you by Conventus Law. In this episode, we'll be discussing regulating data processes by digital lending platforms in India. Joining me in this episode is Arun Prabhu, partner and head of technology and telecom at Indian-based law firm Siro Amachad Mangaudas. Before getting to the heart of the matter, a message from our sponsor who generously supports this podcast.
Ashford Benjamin was founded with the belief that search firms should offer a better service to clients and candidates. This means taking the time to provide a genuine partnership, understanding our clients' and candidates' needs, and proactively advising on the best course of action, utilizing the decades of experience in our industry specialisms, including risk, compliance, business and legal recruitment consultancy, located in central Hong Kong, serving Asia Pacific.
Welcome back, Arun.
Hi, Stephen. Pleasure to be back with you.
Yeah, great to have you on again. On our last episode, we spoke about the tech sector, what's happening, and it was really interesting stuff. We focused on a data protection bill and how that may impact business. But as you underlined, it's early days, but hopefully we'll have a positive outcome on that. In this episode, we are focusing on more data processing by digital lending platforms. We are seeing sectoral regulators such as RBI releasing guidelines regulating data processing by digital lending platforms. Can you tell us about these guidelines regarding in relation to the digital lending and how these guidelines would interact with the bill that's upon its enactment?
Interestingly, one key difference between this bill and the previous iterations of the bill, while all legislation was supposed to prevail over contradictory legislation or previous legislation, earlier versions had this concept of a memorandum of understanding. So basically, the regulator in the previous editions was supposed to sort of sit with other regulators, sign some sort of MOU, and then, the harmonized concept would sort of be put out. This bill doesn't do that. It just says, look, to the extent there's an irreconcilable difference, this bill will prevail, right? So what's very interesting, of course, is that because the bill has been simplified and it's been made a little more high level, fundamentally the likelihood of those direct irreconcilable disconnects actually falls quite significantly. As you mentioned, sector regulators are, of course, trying to sort of step in. To some extent, the pace of innovation and the impact in terms of retail investors in the retail market in financial services is far more accentuated than there is in general data processing. This is stuff that's on ground, it's happening. We've had a bit of a sort of significant regulatory visibility as far as the actions of certain types of lending platforms, particularly those anchored out of certain countries, have had in India. It was a bit of a rallying cry. There were people whose family members were getting calls for recovery. Basically, extremely aggressive practices led to a bit of a regulatory spotlight on the industry. There were some unfortunate incidents which happened where somebody just couldn't take the strain of it. So that kind of led to regulatory focus that led to multiple rounds of consultations on this. And eventually the platform, the framework which has sort of come out of that is actually very interesting because it actually, to my mind, is one of the clearest examples of the principles of constitutional data protection and privacy, which has been laid down in the 2017 Supreme Court judgment in Puttaswamy, being implemented by a sector regulator. So it's actually one of those cases. It's what the digital, data protection bill was supposed to do, but through the lens of sector regulation surrounding digital lending. So it does multiple things. Firstly, of course, it recognizes that the entity doing the lending or the digital lender may potentially use might be a regulated entity. The regulated entity may in turn use outsourcing providers to provide services to enable this digital lending. So you may have technology platforms, software platforms, recovery services, contact services, so on and so forth. So it basically enables some degree of unbundling rather than seeing it like a monolithic whole and saying, hey, the licensed entity should do the entire scope of activities. It actually allows certain amounts of unbundling there. And then it lays down some clear guidelines around what is permissible and what isn't, right? And those guidelines actually for a privacy lawyer are actually quite familiar. First, of course, it's just transparency, right? It requires you to, in very simple terms and very clear terms, go back and specify exactly what the terms of the loan are, what the terms of the liability exposure, interest rate, etc., etc. But it also requires transparency around information. So fundamentally, it requires you to have a clear policy on the basis of which this data is collected, stored, and processed. It requires the policy to clearly indicate what you're going to do in terms of that data. It requires you to maintain and when you outsource functions to other people, say you've got someone acting, providing you with services on contacts, or someone providing you with KYC services or whatever, you need to exercise due diligence during that outsourcing to make sure that the outsourced service provider is sort of compliant. Lastly, on certain kinds of things, it actually hard caps it. So for instance, one of the ways in which digital lending applications work in India, as they do elsewhere, is for people to look at information that's on users' phones in order to determine whether they want to lend to them or not. Now, again, it clearly sort of, it requires that whatever is being done, whatever's being reviewed, whatever's being analyzed, obviously clearly be disclosed and sort of you get a clear opt-in from the user. But quite apart from that, it places strong restrictions on certain kinds of information. So some types of information you simply cannot access as a digital lender. That's hard coded and now stopped in statute. So it's actually an interesting balance between saying, hey, get consent, and saying for some things you simply cannot get consent, which is going to say that these are egregious. So very, very interesting balance in terms of those guidelines. And I see it as a sign of things to come, especially with more sophisticated regulators and industries which have more high impact in terms of end users. I see regulation of this type being increasingly common. In terms of how it's going to work with the sector regulation, with the digital data protection bill, I do believe that overarching principles. There is a consent notice under that format. There is a requirement for reasonable security, practices and procedures under that format. There's a breach notification mechanism. There's a regulator there, and so on and so forth. I would think that once these two frameworks are both sort of stood up, it would make sense for someone to go in and say, hey, here's a privacy policy under which you collected my information, albeit for lending purposes. But you've used that data in a manner which is not compliant with law. It's not, compliant with, say, purpose limitation, storage limitation. You didn't take my consent for the purpose for which it was used or whatever. And I, as the user, will actually have two means of enforcing this. One, of course, is to write to the sector regulator, which is the Reserve Bank, and say, hey, look, this industry is behaving badly. But under the other framework, I actually have an immediate grievance mechanism, which has to respond to me within 7 days to raise a grievance on a privacy basis. So fundamentally, you will have offenses which are going to be both privacy offenses and regulatory, non-compliances at the same time. And to some extent, the subject will be empowered. The other option, of course, is that, at some point, the RBI sort of steps back and says, look, all things in relation to collection, processing, and storage of personal data will be in accordance with the general data protection law. That is possible. They have, for instance, done it in certain other circumstances. So that is a possibility as well.
If you're in the finance industry, it is quite common, especially in the last 20 years or so, that you're under more scrutiny than say compared to another industry, and for obvious reasons, right? Like you mentioned those personal issues people face, the extreme pressure from the lenders, for example, to what happened in 2008 with the global financial crisis, etc. So it makes sense. So I guess this is nothing. It's not unusual, right? I mean, this is would it be fair to say this is above expected outcome of the reforms?
Absolutely. I think what is unusual is the extent of focus on data and the extent of focus on information collection, storage, and processing. Financial regulation has been very common in India, but it's been focused on things like interest rates, APR, disclosure, fair practices, and so on and so forth. The focus on technology and the focus on data that these guidelines actually put out, and fairly so because they're digital lending guidelines, I think is potentious of what might potentially come later whenever so the Reserve Bank of India interestingly created a fintech regulatory department, right, to just regulate financial technologies. So I think this indicates an increasing focus on the technology aspects of a regulation, and of course, by logical extension, the data aspects of regulation. So that, I mean, I wouldn't call it unusual globally. It certainly isn't. But for India, it's a welcome direction, and it's an increasing focus.
Yeah, I think you're absolutely right, and also data, right? I mean, it's so transcendent, isn't it? You know, is relevant for every sector. So I guess it makes sense. And I would also imagine there'll be a lot of crossovers between the industry regulators and the general bill that's going to come out. So I would imagine there's a lot going on there as well. So that's as you say, it's welcome developments indeed. Now, another sector, the Department of Telecommunication (DOT) also released the draft Indian Telecommunications Bill. What are the features? What are the key features of the Telecoms Bill, and how does this propose to regulate over the top communications platforms?
So this is an interesting one. So I think essentially, the telecom legislation was intended to replace and sort of refresh the existing legislative framework. Unlike digital data protection or indeed Digital India, this framework actually is fairly robust. It's been in place. It's been in place for many years. There's a regulator. There's an appellate regulator. There are several licensed operators providing telecom services. India is an interesting telecom market in terms of concentration and so on and so forth. But it's a rapidly evolving one with tremendous amounts of capital and investment going in from industry. So it's at that time that they sort of come in with a piece of legislation to sort of completely refresh the underlying framework on which this whole structure is built. And the key intent here seems to be simplification. The intent here seems to be to minimize the amount of paper, simplify the process in which this is put out, and simplify the regulations which are applicable to the industry. Which to my mind is in keeping with the broad themes of the bill. I think in a couple of places, the way in which parts of it have been crafted may have, to some extent, been a little bit overreaching. So it's been sort of an unsaid rule that there will be a distinction made between content and the carriage. So your regulation, and this is globally true, you have underlying regulation that governs the operation of telecommunications networks, right? And people are either licensed or permitted, or in some cases not licensed to operate these telecommunications networks and provide telecommunication services. And almost everywhere in the globe, you see some level of ability for interception and lawful interception and monitoring. For in some places there are tariffs and license fees and so on and so forth. So that's actually, but what has been sort of unsaid fundamentally is, and there are exceptions, of course, in certain kinds of jurisdictions where there are very light obligations, but basically services that operate on top of these networks, right? So whether that's internet services, whether that's messaging services, conferencing services, and so on, have generally been thinly regulated. They haven't really been regulated at the same level as the underlying networks. What this bill did is expanded the element of telecommunications networks and telecommunications services in particular to cover, to some extent, the provision of services on top of it, especially in relation to messaging platforms. So fundamentally, if it were read in its most stark fashion, a WhatsApp or a messaging service of that sort would effectively become a full telco. And that would obviously mean licensing, tariff, revenues, interception and monitoring, et cetera, et cetera. So again, lots of comments have gone in on this. This is obviously a draft that came out. Lots of comments have gone in on this. There's been a lot of public consultation on it. Fundamentally, the sense we have here is that, as far as draft legislation is concerned, one hopes that some of these sort of more egregious consequences can be resolved definitionally. There have been suggestions which have gone in on how definitions can be narrowed and tweaked to sort of stick to the lane of saying, hey, this is telecom services. It's going to be regulated as a telecommunication service. There will be licensing for it and all of those various hoops that you have to jump through because you're offering a telecom network. But if you're someone who's operating a software service on top of that network, then you will actually be regulated under the Information Technology Act and data protection laws and sort of the Digital India Act as an intermediary or a provider of digital services. One hopes this will be resolved in the definitional aspects of this. But as it stands right now, the bill both has some strong positive and negative connotations as it currently stands.
Where does social media platforms sit on this? Are they considered? Would they be considered messaging services?
Yeah, well, technically, right, and it's again a case of unbundling. So when you're looking at their one-to-many function, which is basically when you're just putting out a post like a Twitter, I frankly don't think the intent of this legislation is to cover those kind of services. I don't think, I mean, yes, the language can be read to cover them, but fundamentally, I don't think that was the intent. But I do think like a P2P messaging aspects of these platforms, whether that's Facebook Messenger, or, any of the other sort of P2P aspects of it, I think those are intended to be squarely covered here, or at least were intended to be squarely covered here when this was drafted. One sort of tantalizing suggestion which has come out is to really, and the argument here, of course, is convergence, right? If I'm a telecommunications company and I allow you to send me a message or make a call to me, I'm regulated as a telecommunication service. I have to pay a tariff for it. I have to pay blah 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 blah. Whereas if I do the exact same thing using the internet and a software service, I don't have to pay anything for it, and I'm not regulated at all. So the argument here is convergence, but I think there are unintended consequences of sort of going down that road. One interesting opportunity, of course, is some form of registration regime, right? Saying, hey, come and register. And to the extent we actually send you a notice saying this is illegal communication, intercept it, monitor it, blah, 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 you'll have to do so. I think that's the direction that this is moving in. Again, that's not without its concerns, but at least it's a better position than saying, hey, full telco license for this.
Thank you again. We've run out of time for this episode, but thank you for shedding light on the telecom bills and the RBI guidelines. So thank you very much for that again. I look forward to talking to you next episode. And again, thank you for coming on.
Thank you, Steve. Thank you so much.
Thank you, listeners, for listening. And I look forward to talking to you on our next episode.